Hello, everyone. Welcome to the Environmental Law Institute's program, A Conversation with Judge Merideth Wright. My name is Madison Calhoun, and I am the Senior Manager of Educational Programs here at ELI. We are so excited for today's event. Thank you so much for joining us today. I also want to give a huge thank you to Judge Merideth Wright and Christine Perry for speaking at today's webinar. We will have time for questions at the end of today's event. Should you have any questions, please pose them in Zoom's Q&A box. You do not need to wait until the end of the program to ask your questions, though. Please go ahead and enter them into the Q&A box as soon as you think of them. I will now introduce and turn things over to our fantastic moderator. Christine Perry, our moderator today, is a staff attorney at ELI committed to advancing human rights in the environmental context, with a particular focus on gender and disability. She works primarily on international issues with a focus on Latin America. Prior to joining ELI, Christine worked for Amnesty International, International Secretariat's Law and Policy Program. Her work on international human rights focused on the rights of persons with disabilities, gender, policy development, and strategic litigation. Christine holds a JD from the Ohio State University Moritz College of Law and a BA in Spanish and Creative Writing from Denison University. I'll now turn things over to you, Christine. Thank you all so much.
Thank you so much, Madison, and thank you, Judge Wright, for joining us today. Before I introduce Judge Wright, I'd like to say a little bit about today's event in honor of Women's History Month. We were thinking at ELI how to honor really the trailblazers in the environmental law and policy field, and who else comes to mind but Judge Wright. She's had a really incredible career, and I'm so excited that we get to share it with you today. As Madison said, please feel free to pop your questions in the Q&A box, and we'll answer them as we go. So without further ado, let me introduce Judge Wright. Judge Wright is currently a distinguished scholar with the Environmental Law Institute. She retired in 2011 as one of 2 environmental judges for the state of Vermont. She had presided over the Vermont Environmental Court, now known as the Environmental Division of the Vermont Superior Court, since its creation in 1990. Before her appointment to the bench, Judge Wright worked on environmental enforcement cases and providing program advice to the state's environmental agency in the environmental section of the Vermont Attorney General's office, and as a staff attorney for the Vermont Supreme Court. Before moving to Vermont in 1978, she worked for the U.S. EPA, for a small Washington, D.C. public interest law firm, and for a prosecutor's office. Judge Wright earned her JD in 1974 from the University of Chicago and her bachelor's degree, magna cum laude, from Yale University in an independent environmental studies major. Thank you so much for joining us today, Judge Wright. My first question is, we're going to go back a little bit before you started your legal career, and why did you choose to take a legal route for environmental issues versus, say, a graduate program of another type?
That's actually a very interesting question. And it was not so easy to decide what to do. First of all, when I was in college, there weren't any environmental studies majors. And I had started college at NYU in a interesting interdisciplinary studies program that only lasted for a few years, but because of it, it was an opportunity to put different areas of study together and come up with not necessarily answers, but understand questions from a much broader point of view than most universities were using at that time. And when I transferred as one of the first into the first graduating class of women at Yale when Yale became coeducational. And in order to not have to take just required courses for my only 2 years there, I put together an interdisciplinary studies program, an environmental studies program for myself, which required using different faculty advisors and so on. So I was graduating from college with a kind of practical interdisciplinary point of view, with an interest in carrying out environmental work. And it seemed to me that something like a law degree would be a better way of being able to do work in this field. It would have been certainly interesting to go to a graduate program, and but what people say about graduate work is you learn more and more about less and less. That is, you get more and more focused into a particular area of study, and that was kind of contrary to the effort that I wanted to make to do something out in the real world that would make a difference. So, and I actually was awarded a fellowship to do graduate study, and I wrote to the program to try to get the National Science Foundation to try to get them to let me apply it to law school. And they said nothing doing. So that was the choice of law school. Now, when I went to law school, there wasn't any kind of environmental course. There was one pollution course in my third year of law school, but that was it. So a lot of it, even through that period of my life, was make it up as you go along.
So that you had this interest in environmental law and policy from your undergraduate going into law school, wishing to continue that. When you started with Dade County after law school, were you hired to work on environmental issues, or did you forge that path yourself?
No, I forged that path myself. In fact, it really was just, I never intended to stay in South Florida, but it was a good job right out of law school. Most of the people who started in a prosecutor's office like that, they were interested in getting out of misdemeanors and into felonies or into the appellate section as soon as possible. And so I did two things in that office. One was to help revise the intake system so that we had a better way of taking complaints from individuals and funneling them to the right people, instead of kind of chaotic system of dealing with people who were victims of crime. But more importantly, from the point of view of this conversation, I kind of sought out all of the environmental prosecutions, which were largely either wildlife, because South Florida has a real, both an endangered species and a sort of this was before the pythons, a sort of year-round animal poaching and hunting out of season problem. And there were a lot of cases involving drinking water, because of the way that drinking water is an issue there, and nobody wanted those cases particularly, so they were being haphazardly prosecuted, and I kind of pulled them all together. And so I was only there for a year, but I think I made a difference in the way those were treated in the courts.
And then moving from Florida, you came to Washington, D.C. How was that switching from being in a prosecutor's office to going to private practice?
Well, it was that's why I always describe it as a small public interest law firm, because it wasn't that different. In other words, I still felt that I was doing the right thing. And the law firm did civil rights and consumer and environmental kinds of cases. And it was very, very interesting work. But it turned out to really not be feasible for me to try to be supporting myself in that law firm. Everyone else in the firm, wasn't very big, had some of either family money or some a spouse who was working at a better paid job, and I just couldn't afford to continue to lose money at that practice. So that then sent me to my stint at the EPA.
And when you were at that firm, was it common for firms at that time to be working on environmental issues, or was that newer?
Well, I suspect it was quite a bit newer. This was in the mid-70s. It was at the time of the founding of a lot of the environmental organizations and firms, and EPA had only been in existence a short time too. So, but I wouldn't have known at that time how usual or unusual it was.
And then right after that, you did move to the EPA. Can you tell us a little bit about your time working for the EPA?
Well, I was in the general counsel's office and worked in what was then called the Air and Solid Waste Division. John Bonine, who worked for very many years in Oregon, in the University of Oregon environment, and started their serious environmental program, was there. He was in charge of that division. And at that time, actually, when RCRA was passed, which was 1976, I was the only attorney working on this new statute. So I focused on that for the most of the time that I was there. One of the things I had to do there was figure out how many lawyers carrying out that, both for the program and in general counsel's office, that statute was going to require. And nobody believed me, but I think there are more than that now, and have been for a long time.
And I mean, this was one of the earlier years for the EPA. Was it trying to get a sense of how was it working there? Was everyone really excited, but thinking this is a new agency, we're gonna, it's the birth of something?
Well, yes, I think we were all perhaps a bit idealistic, but that's not a bad thing when you're starting out to do a kind of new work. And I think there were a lot of very, very capable people there, and advising the programs on what was possible to do and not to do. And it was an exciting time to be working in the federal system.
Thank you. And to our audience, remember, you can pop any questions into the chat. So it looks like after the EPA, maybe you got a little tired of DC summers. I don't blame you. And went for a cooler climate to Vermont, which is absolutely lovely.
Yeah, I think what we were looking to do was to find, my husband and I was to find a place. This was just at the end of the Carter administration, to find a place, even with very well-meaning and dedicated people. It's very hard to move the whole federal government in any direction. It's like moving a battleship. And we wanted to go to a place where we could make more of a difference, and looked in New England and ended up in Vermont, where I had gotten a job with the Vermont Attorney General's office.
So that's interesting. I'm gonna jump ahead a little bit, but talking about the federal and then working more at the state level, and now you do a lot on the international level. So, you know, looking at the three that you've had ample experience in, you know, I'm sure that each has their own challenges for you.
For sure. Well, they're very different. They're not enormously comparable because, as you know, I haven't really worked at the international level. I've worked in different countries comparatively rather than with any international organization. So I don't have experience with, and there are many people within ELI who do have much more of that experience working with international, either on international treaties or with international compliance organizations. I've attended many of those kinds of conferences with different countries, especially about environmental courts and enforcement, but I haven't been working in an organization that has any authority in that field. It's all, and then when we've worked in individual countries, it's been on projects that were at the request of the country. So, you know, they want you to be there, and it's very different.
Right, we are going to take a question from the audience, actually someone from the EPA, your old stomping grounds. And this
Very
question
long ago.
This question asks if you can share your experience at the General Counsel's office in terms of managing the interests of various actors in environmental decisions, policies, and laws.
Well, I'm happy to do so as far as I can recall it, but I don't think it's very comparable to anything that's gone on since I've left there. Basically, I haven't followed very much about what it's like at the agency since then. We were carrying out, as you can imagine, if you look at the time frame of the different federal environmental laws, we were carrying out some very new statutes. So the regulations were being developed. We would advise the programs on what might or might not be successful in those regulations, you know, what the pitfalls were. I wasn't involved with too much litigation, although I was the point person for EPA on some litigation handled by the Justice Department. There was a lot of back and forth. Everyone was rolled, you know, the attitude was roll up your sleeves and do what needs to be done, which was very much the way I like to work.
I was in a conversation the other day and someone asked a speaker if you could have any magic tool to help you in your job, what would you want? And I thought, I'd want a crystal ball. Probably applicable also to your time in all of your jobs?
I don't know. I don't know if I would have. I'm not sure it's terribly helpful to be able to look too far into the future. At least, I think, at least back then, we felt that what we were doing could make a difference. And I think we did make a difference. But I think if we could have looked forward, 50 years into the present, it might have been a little depressing. So I'm glad that I was able to have that that attitude for so long.
And then once you moved into working for the state at the Vermont Attorney General's office, how did that compare from your time working for the federal government?
Well, in certain respects, it was similar that in other words, that the AG's office advises the program. At that time, I'm trying to remember if there were program attorneys I think there must have been, but the AG's office was sort of the attorney for the health department or for the natural resources agency. And so in that sense, it was similar, but we also, and our primary role was to bring cases on behalf of the agency. And that was very different. It was more, in some senses, more like the state's attorney's office, but these were civil cases primarily under the state versions of the various environmental enforcement laws. And that was very interesting because to some extent, you couldn't bring every case, but it was important to bring more cases than the ones that you knew you could handle if they all went to trial, because they don't all go to trial. And if you hold back and only bring the 3 or 4 cases that you think you could handle, there wouldn't be enough enforcement to make a splash in the consciousness of the regulated communities. So it's an interesting balancing act. And we made the decisions. It was just a 2-person office section of the Attorney General's office. You have to understand how small Vermont is. But we made the decision sometimes to bring similar cases from different counties all over the state, or to, it wasn't always the worst case that you brought. You might want to bring a variety of cases so that the regulated community felt that everyone was potentially, could potentially be involved in a case, so that people would, it's sort of like the tax system, if people don't file their taxes because they're terrified of getting caught. There's a general feeling that this is what you have to do. And then there are probably, I don't know in the tax field, but there are probably enough audits brought or enough cases brought, or used to be, so that people would feel that it wasn't an empty idea, that they could be supervised in that way. And this is sort of similar, except Vermont is so small that everything would get publicity, and you wanted to make sure that it was clear that this was a widespread and fair process.
And around this time that you were working for the Attorney General in Vermont, you are also starting to teach at the University of Vermont. Would you say that environmental law classes or classes dealing with environmental issues were becoming more popular in the
Well,
curriculum?
yeah, again, the University of Vermont doesn't have a law school. And the Vermont Law School is located quite a distance away from the university, and was making a name for itself, but it was also quite new. It was making a name for itself in the environmental field. So the courses that I taught at the University of Vermont were to natural resources graduate students who wanted to know something about the legal side of it. And then when I taught at the law school, it was in their summer program, which is about half law students learning about different environmental science areas and about half environmental scientists or graduate students learning about the legal side of it, which is very interesting to have a mixed class of both of those. So you're interpreting two fields to each other, and that's where one of the places in which having some kind of, if not a science background, at least a comfort level of working with environmental science as well as environmental law was very useful to me.
And now I think we have about half of our program left, and I'm really wanting to get into your work with the courts, which led to your appointment. So you did leave the Attorney General's office to be a staff attorney with the Vermont Supreme Court. Do you think that helped forge your path to the environmental court?
Well, the environmental court didn't exist at that time. So but I'm sure that it helped me to become much more knowledgeable about the operation of the court system, not just appearing in front of judges, but seeing how the court system in Vermont has no intermediate appellate court. So there was just the trial level courts and the Supreme Court. And it was also very helpful to see how cases came up to the Vermont Supreme Court and how they were handled. Mostly what I worked on there was helping to figure out ways of making the cases move more smoothly through the system so that the ones that were languishing could be moved along, and that was also helpful. Another roll up your sleeves kind of thing to do. People have to understand that the whole development of computers and computer docketing technology and calling up reports on how long cases had been pending, and that was all being just developed then. So we didn't have those tools. And if you'd asked me about the tools, that might have been something that was, I of course couldn't have conceived of it at the time, but it's enormously helpful to have computers. When I was at EPA, they had just developed word processors that did a single line of text, recorded a single line of text at a time, and then the printers went, this way and back again to print. And it seemed like a miracle that you didn't have to use, backspace and the kind of erase your film to fix your typing. And it made a big difference in how people composed their work, because for the first time you could kind of cut and paste your work and not have to have it completely retyped.
I hadn't thought of that. I guess I've always had a computer. So, and knowing my typing skills, I don't think I would have thrived.
No, I was a terrible, well, I wasn't a typist in when I was in high school. If you were going to college, you didn't learn to, if you were female and going to college, you didn't learn to type because somebody would make you be a secretary. So typing was for the people who weren't going to college.
I did not know that.
And I always envied my husband, who had taught himself to touch type when he was ill as a child. And I could have used touch typing for a lot of my life, but I got much faster once computers came along.
My next question, it's going to be a big one. It's about the Vermont Environmental Court, which is now called the Environmental Division of the Vermont Superior Court.
You can still call it the Environmental Court for our purposes today.
Great.
Mouthful.
So you were
changed. It hasn't changed in its functioning. So yeah. So go ahead. Sorry.
You were its first judge. How did you tackle that? How did that come to be that you became its first judge? How was it set up?
Okay. Well, as is true in many, many places, and you and I have both encountered this in other countries, many places have strong environmental laws, but spotty environmental enforcement. And this is by no means necessarily a problem with the environmental enforcement people, but has much more to do with the resources and tools available to the enforcement people to carry out their work. So in 1989, the Vermont legislature passed a law called the Uniform Environmental Enforcement Act that was aimed at changing or providing a new enforcement tool to the environmental agency. And this was a administrative order authority to issue environmental enforcement orders that were unilateral. This is not after a hearing. This is the agency's own order, much as what is done by the U.S. Environmental Protection Agency. And they had to decide if this kind of an order was going new authority, which could include money penalties, civil money penalties, as well as orders to take action or to stop doing something. The legislature wanted to be sure that someone receiving one of these orders would have very swift recourse to some kind of a body, an independent body that would be able to determine whether the order should stay in effect. And actually the agency, the legislature debated, should this be an administrative tribunal like what US EPA has in the Environmental Appeals Board, or should it be a judicial branch court? And if so, what sort of court? And so this was debated back and forth, and it was really only very close to the passage of the law that it settled on creating a new court. an environmental court. And just to make the terminology even more confusing, this was called the Environmental Division of the Judiciary at that time when it was first passed. And the statute appointed a judge or created a judicial position to serve that court. So this court was not something, unlike the environmental court that was created in Hawaii in 2015, this court was not the idea of the judiciary. This court was, in some respects, foisted on the judiciary by the legislature. And it was something of a surprise to them. So the judiciary in Vermont, because there are trial judges who are assigned, who have an assignment for a year or two and then rotate to another court. And the legislation, because of that, knowing that, the legislation initially said that the judge couldn't be assigned to anything else. And that was not what the people who manage the judicial branch wanted to be told. So it was a kind of an interesting beginning to the court. There was the ordinary judicial selection process, which went, Vermont has a merit selection process and an appointment process, and went to the judicial selection, the nominating board, and so on. But once I was appointed, I got to set up a new court, which was very interesting and a lot of fun. And again, one of these roll up your sleeves kinds of things, but there were very few resources allocated to the court. And there were a number of decisions that I made, which not judicial decisions, but decisions about how the court would operate, that I think might have been different from what the judicial administration thought was going to happen. To start with, I declined to have an office in the same location as the Natural Resources Agency. I thought between the name of the court and the location that it would be just seen as a kind of rubber stamp to the Agency of Natural Resources. And since the reason for the court was to create, and it was extremely important when you're starting something where you're giving the administrative agency additional powers that hadn't previously existed. I mean, this was not an instance of just transferring jurisdiction, which already exists, to a specialized court, as was done in Hawaii. So I thought it was very important for it to be clear that this was the judicial branch court. The statute gave an opportunity for a hearing at which the administrative agency had to prove its case to the judge, that having it in a building, in the same building as the agency, would be, well, give the wrong impression. So we set it up in, and it bounced around in several offices and then into a courthouse in central Vermont. But so that was one decision. A second decision was to issue all the decisions in writing and make them available to not just to the litigants in the particular case, but make them publicly available, which at that time was to put them in the law library, in the law school library, and to give them to anybody who wanted them on floppy disks. Nobody here remembers floppy disks. And which we did once a quarter for a while until they got picked up electronically, ultimately. So there were decisions like that, but the court was only given a part-time court clerk and no law clerks. The other decision was to hold hearings in the county. Vermont is small, but it has 14 counties. In the county in which, excuse me, in the county in which the case arises, so that people wouldn't, it's one thing to require people to come to a central location if they're doing an appellate argument, but it's another thing to require people to miss work, travel, and get all their witnesses to travel to some central location. And so we set it up so that the actual hearings would be held wherever in the state the case arose, unless everybody in the case wanted it centrally, which sometimes would happen because people would hire an attorney for whom that was more convenient. But having the hearings in other parts of the state at the very beginning, we would use the courthouse in whatever county it was. It was interesting to schedule those hearings, but also the recording equipment. There were times when I actually, trundled the recording equipment to the courthouse, set it up myself, put out the water for the participants, and then went into the back room, put my robe on, and came out on the bench. So yeah, that was also interesting. I'm trying to think of the other decisions about setting up the court, and that's really all that comes to mind for now.
And I know from our work in Columbia that you would stress the importance of site visits. So having the court go where the case was actually, to that county, did that allow you to do site visits more easily and things like that?
Yes, but remember, at the very beginning, the cases were only these enforcement orders where if the person who received the order accepted the order in full, it wouldn't come to court. If they wanted to contest any part of the order, it wouldn't be an appeal, because remember, there would never have been a hearing to begin with. They would request a hearing, and then the agency would have to prove its case or prove the part of the case that was being contested. This did not end up being a full-time amount of work for the court. And but the judiciary felt sort of stuck, saying that where it said the judge couldn't be assigned to anything else. And so then I think the next thing that happened was that an existing kind of jurisdiction, all of the municipal, well, you have to understand that all of the Vermont has land use decisions, zoning and planning decisions that are undertaken at the town level. And then it has a statewide land use law called, or affectionately referred to as Act 250, but which at the time was still being heard, and all of the state level permits were still being handled in their various ways, not involved with the environmental court. But the next thing that happened was all the municipal appeals of zoning decisions, land use development decisions, and enforcement of those municipal decisions was transferred to the environmental court, and that was plenty of work. And they also then the requirement was changed so that I ended up being assigned also to do kind of substitute judging work in other of the civil courts in the state. And then later in 2005, the state land use law and the state environmental permitting laws were the subject of another state statute involved with, I think it was called the Consolidated Permit Appeals Statute or something like that. So all of those cases, which had been, some of them had been appealable, some of them hadn't been, some of them had been sent to various administrative tribunals. Those were all consolidated into the environmental court, and then a second judge was added.
So 15 years of that heavy caseload, and then they give you a colleague.
But more than twice as much work. So
That's a very, I mean, it's a huge undertaking setting up a court, and really the first state environmental court in the country.
Yeah.
Did you, when you were setting it up, I know now it's really common to share experiences internationally between judges, but when you were setting it up, there wasn't that network, was there?
no, and it was, I can't think now what was the first time I was invited to a international meeting. I think it might have been one held at Pace in 2004. It was in connection with something that was going on at the UN, I think, and there were a number of judges from and environmental lawyers from different countries, and Tony Aposa, who had brought a landmark case in the Philippines, was a speaker. And at that point, it was just so wonderful to be among colleagues. There's a very flourishing environmental and land use court in New South Wales in Australia. There's an environmental court in Sweden, and both of those are much more similar to the Vermont court than you would expect. And so it was really wonderful to meet colleagues from other countries who were doing the same kind of work, and we've been fostering that kind of interchange ever since.
I am going to look at the chat. There are a few questions. This one I'm going to change slightly, but it's talking about to the federal bench that public interest lawyers are rarely appointed. Would you say, is that similar in Vermont, that the appointment usually comes from big firms, or that's not the same issue as it is federally?
I probably could not answer that. I mean, I just don't have the knowledge. I think because Vermont is so small, in some ways it's everything that goes on here is subject to everyone's scrutiny. So you don't have the risks or opportunities for that kind of extreme influence that you might have in places where there are just so many more positions and so much more that goes on behind the scenes. But I'm just not knowledgeable enough to say.
And then another question, this would be taking us a little bit further after your time off the bench and your work with the Environmental Law Institute. This question wants to know about your experience with the U.S.-China partnership for environmental law.
Yes, well, once we started reaching out to or knowing about the experience in other countries, I did quite a lot of work with the what was then called the U.S.-China partnership. I think it has since developed into a U.S.-Asia partnership, because I know they're currently doing work in some other Asian countries. But I worked with that. I went to China several times talking with people about the Vermont Environmental Court and how it worked and how it was set up. And because at that time, China was looking into creating environmental courts, and the way they start to do things there is to set it up as a kind of pilot project in several different locations in the country. I think it was a little bit hard to convey the difference in scale, but most of I'm trying to remember now, but certainly some of the work that I did in China was also involved some of the judges from some of these other, especially Asian and Pacific environmental courts. And I think it was very, very helpful to just have the conversation about these different choices that could be made in the process of setting up a new court. In a lot of places, including China, most of the environmental enforcement is done criminally. And the concept of having a civil penalty that could be keyed to the amount of economic benefit or profit that was achieved from the violation was a kind of new idea. Everybody recognized that most of the set amounts, especially in countries whose currency is devalued, that the set amounts for fines in the criminal process are sometimes laughably too low. But and they were looking generally, and this was not necessarily China, but also some other countries, they were looking at just increasing those so they were higher. But the idea, one of the things that I think was useful was to describe both the Vermont and the US EPA's work on linking the penalty to the amount of profit or economic benefit achieved from which can be the avoided cost of, for instance, of cleaning up or of properly disposing of something, rather than just the profit, company profit. But linking it to that, it was a kind of new concept that was very interesting to discuss with these other countries. I did some work with through the Asian Development Bank, speaking with the consortia of chief justices of a number of the Asian countries, also talking about things that could be done to address these problems.
And I think this will be my last question. So I know that we're wrapping up on our time, but looking at your current work now, especially with ELI, working with judges from around the world, I mean, how important do you think it is for the judges to learn from your experiences? That I know you've said in the past that judges really like learning from other judges.
Well, I think that in the field of judicial education, and this is probably true everywhere, and you have to understand that in the Anglo-American system, judges are way, high up on the totem pole in the legal system. But in many other countries that use the civil law system, the judges are not so highly respected and often will go to become judges at a very low level that's closer to our judicial clerkship concept. And then they might go into private practice. So the idea of who judges are, you have to keep that in mind. But that being said, I think that most judicial education, it's just helpful for judges to know that there are other judges out there who are experiencing or dealing with the same issues, that various court systems have come up with different ways of doing things. And I think it's helpful for not particularly to learn from my experience or other judges' experience in their own courts, but to know that these alternatives are possible. And especially when it is a question of judges being exposed to science or other economics, things outside of their own field in law school, that seeing other judges who have become comfortable with these concepts is helpful. They don't feel like they have to push back quite so much.
That is all the time I think we have for questions today, but I want to thank you so much, Judge Wright. If there's anything you'd like to add, if not, we can turn it over to Madison.
Well, I don't really think there's anything to add in just, half a minute. But I'm happy to hear from anybody who wants to discuss these things further, and we can figure out a way of making that happen.
Thank you.
Thank you so much for your time today, Judge Wright and Christine. This was such a fascinating conversation, and we really appreciate you taking the time out of your day to join us. This concludes our program for today. Please visit ELI's events webpage for more information about future events. We hope everyone has a wonderful Women's History Month and a great day. Thank you so much again.
Thank you.